I'm going to spend a little bit talking about the very basic question of what do we mean when we talk about the law, and then Barbara's going to take over and talk about some of the particularly important legal issues that campuses are dealing with these days. So, just two things on materials. You will find that the last couple of pages of our handout for you have a map of this conference, and they sort of show you what sessions you might want to attend and what recordings from earlier conferences you might want to look at if you're interested in particular topics. I encourage you to take a look at it. In addition, you should know that the materials that are on your little drives and that have been printed out for those of you who have paper materials are not complete. Those of us who are a little late in getting our materials in, this stuff isn't in there. You can get it all online, and I encourage you to look at that before you move ahead with the conference. So, what do we mean when we speak of the law? I had a really interesting conversation recently with an administrator who was really unhappy with the advice that I was giving her. And what she said to me was, "Show me where the law says that." And I had to say to her that in most things we do, it's not that simple. The law comes from a lot of different places, and the reason lawyers have law degrees is because we've learned at least a little something about how to try to put all those different sources of law together to answer questions. Obviously, we all worry about the US Constitution. Then there's federal law, there's state law, you may have local laws that affect what you can and can't do, and then there are private sources of law. Accreditation rules, NCAA requirements are very important for a lot of us. Contractual obligations that you enter into and have the force of law for whatever it is they cover. They're also different, in addition to the different levels of government, there are different sources of law at all of those levels. So there's our constitutional requirements, which, if you're in California, end up being extremely important because California puts almost everything into its state constitution, may be less important in some other states. There are statutes, the actual laws that are passed by the Congress or the legislature. But in addition to the statutes, there are regulations, which are administrative interpretations of what those statutes say. For many of us, agency guidance has become a particularly important source of law, even though it is not really binding law in the same way that statutes and regulations are. If you get a bunch of lawyers together in a room, a bunch of higher education lawyers, they will question whether the Dear Colleague letter of April 2011, which gave us guidance on how we were supposed to deal with sexual assault, whether that really has the force of law. It goes way beyond what's in the statute and the regulations. But the truth is that most of us don't want to draw the ire of the Office of Civil Rights of the Department of Education, so we're going to follow those rules as if they were the law, even though in a court we might prevail in proving otherwise. And then, of course, the hardest thing for people who haven't studied law to get is often the notion of case law. The judges have decided cases, and those judicial decisions have the force of law, and in some areas of the law, they really create the law. And so when you're trying to figure out what's the law on, for example, whether my institution is responsible if someone gets drunk and goes off and has an accident and hurts someone, that's going to combine statutory law, regulatory law, and probably cases decided by the courts of your jurisdiction. We also have to worry a lot about contractual obligations. Accreditation standards are enormously important. for all of us because we need to stay accredited. It's essential to doing the work that we do. There are institutional policies that we have and that we need to follow, not only because they bind us, but because if we don't comply with our institution's own policies, we're in danger of being sued because we didn't follow those and someone at least claims to have been harmed as a result. Many of us have unions on our campuses. There are collective bargaining agreements, which also have the force of law in certain sorts of relationships. And then there are the myriad contracts and memorandum of understanding and memorandum of agreement and whatever else you call them that your institution has entered into with maybe the state, maybe another institution, maybe private third parties. Those of you who are engaged in any sort of international law, in any sort of international operations, and I suspect most of your institutions are, have to worry about the law of other countries too, even though we as in-house lawyers often don't know it. The law of the countries in which your faculty, staff, or students are working. Licenses that may exist in those places, whether you need agency approvals to do work there. What are the employment policies in other places? A bunch of my colleagues at Teachers College are working in Pakistan right now. It was quite entertaining to call a Pakistani lawyer and try to figure out what the employment rules were for those people who were there. But we had to do it because we were employing Pakistani locals and also Americans who were spending multiple years there. Private institutions and public institutions are different. Some of the laws applicable to state institutions are very different from the laws that relate to private not-for-profits, which are what most private institutions in the US are. For example, if you're a state institution, you have open meeting requirements. And Freedom of Information Act, whatever your state calls it, rules. Those of us at private institutions get to skip that. On the other hand, those of you at public institutions have sovereign immunity. There's certain laws that don't reach you, whereas they do reach us. In areas like employee benefits, the rules of private and public institutions are just completely different. So that's sort of a background about the law in general, from 30,000 feet. How is higher education regulated and otherwise subject to laws? Well, first of all, as public agencies, as not-for-profit corporations, or increasingly as for-profit corporations, educational institutions are governed by their charters, that is to say, their founding documents, by incorporation documents, by bylaws, which are internal institutional guidelines, and also by business licenses and other sorts of regulations that you get typically from the state and local level. As providers of higher education, we are governed by laws that are specifically directed at us. For example, financial aid regulations, Title IV of the Higher Education Act, which contains all sorts of rules that really have nothing to do with financial aid, but financial aid is the hook on which the federal government tells us we must do certain things. The Clery Act, is it the case that colleges and universities are more dangerous than other places where people might work or live? I don't think so, but the federal government saw an opportunity to address a deep concern by the parents of a young woman who had been murdered on her campus, and all of a sudden we have enormous regulatory structures within our institutions that deal with Clery Act reporting and warnings and so forth. Title IX, If your campus is like mine, people who'd never heard of Title IX are now spending enormous amounts of time trying to adjust to the ever-changing rules about how we're required to address sexual harassment and other sorts of gender-related misconduct that some of us didn't used to think of as sexual harassment, but now are required to do. And then, of course, we're regulated as businesses. We are employers, we are contractors, we are property owners. Many of us are landlords. We provide recreational and park-type facilities to the community. All of those things are sources of regulation of higher education. So now I'm going to turn it over to Barbara and let her talk a little bit about some of the specific areas. And then if we have time at the end, you can ask us questions. And if we don't have time for your question, find one of us over the next couple of days. Well, find Barbara today, find me over the next couple of days, and I'm happy to try to answer.
Okay, thanks, Lori. I think we'll have plenty of time for questions because I've always found the questions far more interesting than anything I have to say. So. I did want to ask you a question, though. How many of you folks work primarily in student affairs? Okay, how about academic affairs? Looks like about even split. Athletics? Nobody from athletics? Well, I guess I don't need to talk about that then, right?
I guess so.
And the rest of you are just interested in everything, huh? Okay. What I'd like to do is go through a couple of different areas. Is this my microphone that's making that noise? See if that's better. Better? Okay, good. Either that or it's my magnetic personality, right? In any event, what I'd like to do is talk a little bit about hot issues in student affairs and hot issues in academic affairs. As Lori mentioned, I've just finished, my co-author, Bill Kaplan, and I have just finished the 5th edition of our book called The Law of Higher Education. And the publisher, Jossie Bass, wanted me to write a 10 hot topic article for each of their 6 newsletters, which is, by my count, 60 hot topics. So I'm well prepared to talk about hot topics today. So I'll start with student affairs. Lori mentioned briefly the issue of Title IX. If you are on a campus where a Title IX bombshell has not hit, you are lucky, or the people on your campus are, drugged or something, because this is an issue that schools, small and large, are struggling with right now, is in dealing with students who are angry because they feel that their complaints have not been responded to appropriately, whether they have or not, I think sometimes seems beside the point. And the Office for Civil Rights that is being accused of being too lax. No higher education lawyer would ever say that the Office for Civil Rights has ever been too lax, but the students seem to feel that that agency is not performing its watchdog role that the students feel it should. And you see institutions from, and this has been in the Chronicle, so I'm not telling any secrets, small elite places like Swarthmore colleges, big sprawling places like the University of North Carolina at Chapel Hill, and every state in between have had issues with Title IX and sexual assault. It's very, very important to do the training that the Office for Civil Rights suggests. It's very important to make sure that staff members, at least one of them, understands the nuances of the way that the Office for Civil Rights is interpreting this law, which, as Lori suggests, is of their own imagining in many ways, but they're the agency that enforces it, so we have to salute and say, yes, sir, or yes, ma'am, as the case may be. So I don't think I need to tell you how important that issue is on campus and what the legal pitfalls can be if somebody takes a wrong step. I just finished a paper on student challenges to academic misconduct, and about 10 or 15 years ago, students really didn't think about, well, maybe they thought about it, but they didn't take a claim to court challenging a dissertation committee's flunking of them, for example, or the determination of a professor that a medical student or a social work student or a student teacher did not pass the clinical portion of their program and would not be able to get the license that they were looking for to be a doctor or a social worker or a teacher. These claims have mushroomed over the last 5 years, I would say. There's a very interesting case that came out of the Ninth Circuit against the University of Oregon, where a student whose dissertation chair resigned because she accused him of being sexist and not being helpful. She sued him and the institution for retaliation under Title IX, and the Ninth Circuit is letting that go to trial. Now, 5 years ago, I don't think she even would have sued, much less have successfully convinced a court that she could go to trial. So these claims where in the past courts have been extremely deferential to colleges and universities, saying if it's a faculty's professional judgment, we're not going to try and insert ourselves into that process, that is now very much a judicial issue. Sexual orientation and transgender issues. I'm from Rutgers University. We have 65,000 students. So as you might guess, we have a number of transgender students or students who are questioning, not too sure where they're going to go with their gender identity. And it has implications for housing, it has implications for locker rooms, it has implications for intercollegiate athletics, or even regular club teams. And these issues need to be treated with sensitivity. There are a number of states that protect transgendered individuals from discrimination. Certainly not all of them, but about a quarter of the states do so far, and I think more are probably going to come. And these are awkward cases. I don't necessarily mean awkward legally, but awkward because your faculty may not understand the sensitivities that the students have, particularly if they're my age or older. They've probably never encountered an individual who's transgendered. So again, an important student affairs issue that can have legal consequences, that can have public relations consequences, and that many schools are facing for the first time. Cyberbullying. There's actually a session 4A that's going to talk about cyber issues. But cyberbullying, and again, being from Rutgers, we're a little sensitive to this issue with the suicide of Tyler Clementi. We now have a state law that outlaws bullying, not only in the public schools, but in colleges and universities as well. And it's an interesting question how that squares with free speech and with other freedom of expression sorts of policies or practices or concerns that any institution, whether it's public or private, might have. I teach a higher ed law course to college student affairs graduate students, and I think this is one of the biggest issues that they face. Facebook comments, roommates don't confront each other anymore. They just put nasty stuff on Facebook. And it's a serious interrelational problem with for student affairs people, and it also can be a legal problem, particularly if there's a crackdown in attempting to regulate it, which may be difficult, particularly at public institutions. Students at risk or who threaten others, again, 1 out of 5 Americans has mental illness. And we're seeing more and more students who have these challenges on our campuses. And we obviously have to deal with them. I suspect everybody in this room has had an encounter like that with a student who was troubled. Many institutions have what are called threat assessment teams. I know mine does, and if yours doesn't, I think you should very quickly put one together with someone with psychiatric experience, a lawyer, a student affairs person, to keep tabs on the students who are troubled. There's a big misconception that FERPA does not allow us to talk about or share information about students who are troubled, and that's absolutely not true at all. FERPA allows observations to be shared, and FERPA even allows documents to be shared among institutional officials that have let's call it a business need to know about what's going on with a student. And far more important, frankly, to tread on some toes in terms of privacy. Easy for me to say, I don't have to answer to the legal consequences, than to deal with tragedy down the road. So an aggressive monitoring and reaction to troubled students, I think, is tremendously important. And then we have a brand new issue that's just surfaced in the last year or so. When I was in college, and even more recently, if you had tried to bring a pet into a dorm, no one would, they would have sent you home. These days, if you get a psychiatrist's prescription for a comfort animal, the Fair Housing Act suggests that you need to allow that animal into your residence hall room. Maybe not in your chemistry lab or your dining hall, but probably in your residence hall room. And this is just making student affairs people's heads spin. One of my clients just put together a policy for service animals and comfort animals last week because, of course, they have a problem and now they need a policy. And the other way around would have been better. But she had never heard of comfort animals and was not going to include them in the policy. And I said, do you have residence halls? Knowing the answer, yes. Well, then you need to think about comfort or therapy animals as well as service animals. So that's a whole new world. We may have dueling allergies now with people who are allergic to pet dander. Frankly, if my roommate, I actually graduated from UVM a long time ago. If my roommate had needed a snake to quell her anxiety, I would have been the one with the anxiety. So you're going to have conflicts, I think, in this, which is, bring a puppy dog to school. That's exactly not what the issue is. They're far more complicated issues than that. In the area of academic affairs, faculty provocative speech, and actually there's going to be a session, and Frankie and I are going to talk about academic freedom and faculty provocative speech this afternoon. Every time I open the Chronicle, well, I don't open it, I read it online, but every time I read the Chronicle of Higher Education or Inside Higher Ed, there's another story about a faculty member who's been dismissed or yanked out of class or scolded or hung out to dry because they said something that a student didn't like in class. The most recent one was 4 days ago at the University of Wisconsin-La Crosse. I don't know if any of you saw that. The faculty member and I may be revealing my political stripes when I talk about the incident, but the faculty member had assigned a paper for students to do using U.S. Census data. Well, the U.S. Census is closed because of the government shutdown, so the students can't do their papers. Well, this is a gift from heaven for the students, obviously, or at least from Congress. And the professor emailed the students. Unfortunately, she's an assistant professor, so I'm a little bit worried about her future. But she emailed her students saying, because the Republicans/Tea Party have closed down the government, you can't do your assignment. And when Congress decides it's time to go back to work and the Census Bureau is open, get right on that website and finish your papers. Well, she caught you-know-what from the administration, and they forced her to write an email of apology to the students. In the email, she said something like, well, I still feel this way, but I probably shouldn't have said it. So, in my opinion, she had every right to say that. That is not anything that's, when you're talking to adult students and the message is related to the course, I think it was protected by academic freedom myself, but that's not the way she was treated. And we see examples of this all over the country. So this may in fact be going on your campus as well. Another big deal issue for academic affairs folks is, do you offer online courses on your campus? And if so, who owns the content? 100% sure that faculty are going to say they do, all right? 100% sure that somebody in your administration, probably the CFO, is going to say the institution owns that content because the faculty members used institutional resources to produce it. They probably got some technical help. They probably used institutional computers. They probably got some time off to put together new courses. And there's going to be some conflict there, particularly if the faculty member leaves your institution. Can they take that content with them? If it stays on the institution's servers, can some other faculty member use that content? So there's a big flap about that issue going on my campus right now, and I suspect on many others as well. Faculty role in institutional governance. You might think that that's not necessarily a legal issue. I think it is, particularly if you have a faculty union on campus. What does the faculty member have the contractual right to do and to be involved in? What happens if the faculty feel that they are not listened to or that their concerns are not met? I've seen, well, dozens at least, of votes of no confidence involving provosts or more probably presidents across the country in the last year. The folks are getting restless. It may be the economy is prompting some of this. It may be concerns about the dwindling proportion of tenured faculty members at most institutions. But the faculty expect to be given a say in what goes on campus, and it's an issue that's roiling, if not openly, at least below the surface. Employee privacy and social media, another big issue. We have a session on that, session 3B. We'll be looking at employee privacy issues and social media issues. I don't know if you followed what went on in Wisconsin a couple of years ago, but there was a successful attempt by the governor to destabilize the hold of labor unions, particularly among college and university faculty, although in other spheres as well. And faculty members found that the University of Wisconsin at Madison was getting open public records requests for faculty members' email messages connected to political activity among the faculty surrounding this issue of labor unions. And the university had to decide which emails were protected by academic freedom, i.e. those related to research and teaching, and which others were not, because they were not related to the faculty member's job. So you also probably read about the conflict at Harvard, where faculty members and administrators' emails were read in order to ascertain who leaked information about some student misconduct to the newspaper. So these are live issues. They're not, and they may not be happening on your campus, but they're happening at others, and they may in fact come to you as well. And then another issue I think that creates a lot of discomfort and concern is the whole issue of faculty retirement, or more precisely the issue of faculty non-retirement, because many faculty are hanging on to their jobs, and now that there's no cap on the age discrimination law, it's very difficult to predict when faculty members are going to retire. And the nicer the job is, the lower the teaching load they have, the more perks they have, the more likely they are to stay, right? So if you load up older faculty members with more teaching, that's an age discrimination claim. So managing faculty performance is even more important now than it ever has been, and I think it always has been important, but it's more important now with all of us facing shrinking resources and worrying about the shape of our faculty workforce in years to come. And we also have session 1C, I believe that's early this afternoon, where Anne Franke will be talking about what she calls early retirement. I think early retirement means retirement any time before the faculty member really wants to leave. And she's going to be talking about strategies for dealing with retirement and early retirement plans. So that is just a whiz through a couple of top 10 lists. I would be happy to, and Lori would too, I think, happy to have you ask any questions. We've got 20 minutes or so to do it, so we'll open the floor to you folks.
One of the questions in Rutgers is the Pearson materials that were essentially prepared by Pearson, and the graduate faculty, the members of the graduate faculty were open. I could see an issue where an institution is very desirous of going online picks Pearson. My institution talked to Pearson several times, and the faculty argue granting of the degree is an expression of academic freedom, and therefore, if it's material they have not prepared, it's a violation of their academic freedom to grant a student a degree for taking materials in which they had no role in preparing. And there are these vendors of these pre-cooked materials. I think Pearson gives you choices. You can choose course A, B, or C for 101 poli-sci, or that sort of thing. But I can see that becoming increasingly important as institutions desperate for other revenue streams start to outsource the preparation of academic materials. Have you given any instances or any experience in that?
We have a ringer here because Rich Laveau was he's currently president of Bloomfield College and a former Board of Governors member at Rutgers, so he knows of what he speaks. I agree with you. I think it's really, I didn't have anything to do with nor did any faculty member, as far as I know, have anything to do with the negotiation of that Pearson online contract at Rutgers. And we have a faculty union, which actually is the entity that's the mouthpiece for the faculty, although I think it's more than just the union who's concerned, it's the graduate faculty, but the union has been very involved, the AAUP. And I think they have a point. Let's use a different kind of analogy. Let's say a student wants to transfer courses in from a community college or another college. The faculty have to approve that. We don't just say, oh, anything you took at X college is fine. You have to satisfy the academic requirements for the department or the major that you are looking to get. And I would think the same thing would be true for online courses. And I'm really quite surprised and unhappy if, and I'm not suggesting that I don't believe you, but I can't believe that my university would allow a course to be offered that no one in the faculty had approved of. And if that's the case, I'm going to be marching with the rest of them. What do you think, Lori?
Well, I mean, I think this is one of the hot issues right now. I mean, my own institution is trying to think about how we are going to do more digitally. And one of the marching orders from my administration is the faculty have to be involved in this decision. And the reason the faculty have to be involved in that decision is a combination of it's our culture that would be the place, but also it would be just it would be asking for enormous trouble not to do it. I don't know if legally that's required, but certainly politically and culturally it's required. Other questions? Well, I think there are a lot of complicated issues, only some of them are legal. For those of us who are starting to do both distance learning and also let our students do practica and other sorts of experiential learning off campus, and more importantly, out of state, there is an enormously complex web of state authorization rules for us to deal with. Someone on your campus is probably either trying to wrestle with those rules right now or hiding their heads in the sand because it's just so damn complicated. There is a group called SHIO, State Higher Education Executive Officers, that has a wonderful online resource that attempts to guide you about what different states require. And I actually had a meeting just last week where I sat down and said, okay, this group of states we're going to be exempt, and we don't have to do anything. And this group of states we're exempt from authorization, but we have to file something to show that we're exempt and probably file annual reports for them. And this group, the distance learning is enough to put us over the line and require that we register in the state. But this other larger group, they're going to give us a pass on the distance learning, but if we have students doing internships there, or we're paying someone to supervise those internships, that's going to put us over the line. Those are just enormously complicated questions. There is an effort to develop a national solution to them in the form of a reciprocity agreement among the states, but it's complicated. My own state of New York is very unlikely to adopt that because they're concerned that people they think of as fly-by-night educators or educators would be able to get into our state if we accepted any state's authorization. So I think that debate is going to go on for a while, and we're all going to be working very hard to try to deal with it. With regard to international programs, up until recently, the Federal Department of Education hadn't said much about them, but in their latest pronouncement on what they're going to do about state authorization rules, they hinted that they're also going to start regulating international offerings of education. I haven't a clue how they intend to do that, but it makes me really nervous because the notion that we, all of us, might need to be authorized to provide education in every country in which we might have 1 or 2 distance learning students, that is
Ridiculous.
It's insane, but that doesn't mean it won't happen.
Let me talk about the clinical part of your question, because I think we could answer your question for the rest of the session. As many of you know, we're seeing more and more pre-professional programs, not only at four-year colleges, but at two-year colleges, that require some kind of a clinical component and a hands-on clinic for a social work student or a medical, anything related to medicine, or student teaching, or just about anything. So, well, one, you need some kind of an affiliation agreement with the local site in order to deal with insurance issues, in order to make sure that everyone understands that the student is not an employee, in order to make sure that you know who the supervisor is and what that supervisor's responsibilities are. There have been a number of lawsuits brought by students who are injured at the clinical site, and if you have made that clinical supervisor an employee of yours, in other words, you're paying them to supervise, that may in fact mean that that your institution supervises this off-site location, and you're therefore responsible for any kind of harm that comes to the students. There are also issues of grading the student. Does the supervisor, the clinical site supervisor, have the final word in grading the student, and does the institution have to accept that decision? And if they do, and deny the student a degree, you know who is going to get sued, both of you, both the intern site and the institution. And so I think clinical placement is a very good idea. I wouldn't want anybody in the medical field practicing on me who had never practiced on somebody before me. All right, but there are a number of legal issues that have to be attended to, and there are a number of educational issues that need to be attended to as well. And I think thinking all that through ahead of time is very, very important, not only for the quality of the academic program, but for risk management reasons.
Other questions? Yes?
Well, you don't have to have a policy, but there have been 2 court rulings that the Fair Housing Act requires entities that fall under it, and there's still issues about whether colleges and universities are subject to the Fair Housing Act, but 2 courts have said they are. And I believe the Department of Housing and Urban Development has also said they are, so that's sort of an uphill battle for you to say you're not. Those entities have said that if you're subject to the Fair Housing Act, you have to provide accommodations to tenants who have disabilities. And they allow therapy animals, which is not necessarily a dog, all right, and they don't necessarily have to be trained, which is very different from a service animal, which is only a dog or occasionally a miniature horse. But my cousin who raises miniature horses goes like this when I say, is really a miniature horse a service animal? And he says, well, mine aren't. But comfort animals could be any animal that provides psychiatric, not care, but comfort to the individual. So I think if you're thinking about putting together a service animal policy, you need to get some legal advice on the language that you might want to use for a comfort animal. For example, the student assuming, it would have to be a student if they live in the residence hall. Well, I guess it wouldn't have to be a student. It could be a residence hall advisor who may not be a student, who you also would have to accommodate. I would require that they be able to certify that they have a disability that requires this kind of therapy, the animal, and take it on a case-by-case basis. But Susan Wheeler knows a lot more about that than I do. So she's right up here in the orange. So when we're finished, you should come up and talk to her. And that's what she gets for coming to this session.
Yes? The answer to that depends some on what the nature of legal services on your campus is. Well, and that's a challenge. At my institution, I go around to faculty members, particularly new faculty members, and say to them, "Hi, I'm your lawyer." Not individually, only in a collective sense, but I'm here to help you solve problems, and when in doubt, feel free to pick up the phone and call me. Most campuses either restrict access to lawyers so that not everyone can do that, or they, like your campus, don't have lawyers. One of the goals of this conference is not to turn you all into lawyers. There are enough of us already, but to give you the ability to spot issues. What I tell my faculty is, if someone says the magic word harassment, or tells you something else that sounds like they're talking about discriminatory harassment, it's time to pick up the phone and call someone. If someone, a student or an employee, is telling you they have a disability and asking for something as a result of it, you need to contact the responsible office on your campus and not try to solve it by yourself, because in addition to the risk of failing to accommodate someone, there's a risk of over-accommodating someone because you think it's just going to be a week or two, and then by the time you realize that you can't keep doing it, you have a hard time arguing that you can't under the law. I urge people to be extremely careful about what they put in email. Email is forever. It never really goes away. And those casual things that we jokingly say to each other don't have the inflection that you may intend when they turn up in a lawsuit later. I have never dealt with a campus litigation matter that didn't involve an email that really reads differently than the writer intended it. Similarly, people have this notion that their conversations with their colleagues are confidential. I mean, I said it was confidential, so it must be confidential, but it's not really. There are very few conversations among colleagues that are actually confidential. Indeed, one of the reasons that people tend to bring lawyers into the room to do things is because when you are seeking legal advice from an attorney, at least in most jurisdictions, those communications are in fact privileged from the outside world. The other thing that I tell people, and it's in some ways the hardest thing to do of all of them, is read the contract before you sign it. What does it commit you to do? What does it commit the other side to do? Can you really do what you're saying you're going to do? People often sign contracts that obligate every employee of the college to do something. Can you really make every employee of the college, including all the faculty members, do that? Possibly not. So your project is mostly issue spotting, and then the question, of course, is how on your campus is legal advice provided? And I'm hoping that there's someone somewhere on your campus who can connect you to a lawyer when you've got an issue that's novel or might be subject to changing law or just that is risky. Yes?
I'm trying to understand the legalities of medical marijuana on campus and the smokers on campus by those times. So where are we? I mean, they need it. They're usually they do it. We're not come up with a plan, but it's almost like you have to go against the code of conduct that you're defending and not let anybody else know. And it's really, I mean, we haven't really had to deal with it yet because it's a situation where you can do it at home. It's where you come to campus, but in certain situations, students need to do it on campus because of the anxiety. And then you have a problem of allowing people to drive because now they're under the influence and
I don't know. I'm sorry. You also have the drug-free schools and the drug-free workplace federal laws that federal contractors have to obey. And most, if not all, schools have federal money. So you've got those federal laws, you've got state laws, and then you've got, I know in my state, New Jersey, we just are starting medical marijuana, and they actually, I figured you must be, yeah. Well, we can commiserate after this is over. The governor, I don't know if you knew this, but the governor wanted Rutgers to grow the marijuana. The general counsel's office thought about it for about a second and a half and said, sorry, we can't do that. We do have a farm, but we can't do that. So I don't know how to answer that question. Do you, Lori?
I really don't. I mean, and I think, the great challenge, even before you get to the nuances that you've described, you've got a conflict between state and federal law here. And most of us are federal contractors, and we are required, anyone who gets any Title IV funds, any financial aid money from the federal government, is required to tell your students that if they are convicted under a drug law, they're going to lose all their financial aid for varying periods of time, depending on what exactly they've done. So I'm really not sure how we square that. I'd be interested in, I guess if New York passes that law, I'll be on the phone with my colleagues in California and Oregon and Colorado, asking them how they're doing it, because I don't have a clue. And candidly, like most of us, I'm busy with the problems I have today, and New York doesn't seem to be moving in that direction yet, so I can't do any better than Barbara on this one.
I'm sorry. I feel terrible, but I don't know.
Anybody solved that problem yet? Rich, Dave?
We've talked about it, and I think the best you can do is you have the opportunity to choose your plaintiff.
Yep.
Mm-hmm.
And I'd rather be sued by somebody wanting to use medical marijuana than sued by the government to take away funds.
Yeah.
And that way, if you lose the suit, you say we're protected by a judicial order.
Yep.
So that seems to me to be a cynical
Yeah.
way of looking at it.
Well,
But
I agree.
actually, that's a really good point, and to extend the cynical attitude towards this, it is often the case that we all like to avoid litigation when we can, but we also know that if we spent all of our time trying to avoid litigation, we'd fail to make some of the important decisions that we need to make. I mean, I always encourage faculty members and administrators to think carefully about things, to go through things methodically, to follow our rules. But I'm not going to tell them, no, you shouldn't flunk this student out because he's going to sue us. That is a cost of doing business in 21st century America, and you just have to deal with it. But sometimes the question isn't, am I going to get sued, but which lawsuit would I prefer? And I think that happens all the time when you're dealing with students who pose harm to self or others, and you have to answer the question, am I more worried about a potential lawsuit under the civil rights laws for allegedly failing to accommodate someone with disabilities in the way they'd like to be accommodated, or am I more worried about a dead kid? And you know, everyone should reach their own conclusions on that one. I'm pretty clear which way I go on it.
Yeah, I agree. More
Anybody?
questions? They probably want some coffee. What do you think?
I think we let them go get their coffee.
Okay, thank you
Thank
so
you
much.
all very much.